Welcome back to this public meeting of the United States Consumer Product Safety Commission. Our hearing will now resume. Just a reminder, this is a public hearing to receive information from all interested parties about potential safety issues and hazards associated with Internet-connected consumer products. We have heard from two panels already this morning, and now we are going to hear from our third panel. On this panel, we are pleased to welcome Dr. Andrea Matt Wishon from Northeastern University, Mr. William Wallace from Consumers Union, Dr. Mark Stanislav from Duo Security, and Ms. Sonny King from Electronic Privacy Information Center. Welcome to all of you, and again, I know I speak for my colleagues, our sincere thanks and appreciation to all of you for being here, for sharing your expertise and taking the time to come and join us today. So with that, Dr. Ms. Wishon, if you would please proceed.
Thank you for permitting me the time to speak with you today. It's my pleasure to be here with you. I'm Andrea Magician. I am a professor of law and professor of computer science by courtesy at Northeastern University. I'm also an affiliate scholar of the Center for Internet and Society at Stanford Law School, as well as an affiliate of the Atlantic Council Cyber Statecraft Initiative. But before I did any of that, I was a corporate lawyer. So my comments today reflect that knowledge of the innovation lifecycle, as well as my 15 years of research as a legal academic working in security. I also had the privilege of serving as the FTC's academic in residence and senior policy advisor on security and privacy in 2014. Had the privilege of working with the commissioners closely on issues of security and leading a team of FTC attorneys who ran a contest at the DEF CON security conference, which was the first time that a federal agency had run a contest of that type with the consumer protection goal at the DEF CON security conference. I'm also the legal subject area expert reviewer for the DEF CON security conference. So that's the framing of my perspectives on the issues that we are discussing today. I'd like to incorporate my written comments that I've submitted for the record, but if I may, I'd like to offer 5 points that are building on the themes that are emerging from the testimony today and attempting to address some of the questions that have come up in the course of the testimony. First, I'd like to highlight from my written testimony that the FBI has issued a consumer protection warning that IoT children's toys expose children to physical risk. I've provided the citation in my written testimony. And an additional dimension to that risk arises from the dangers to national security that are presented by IoT botnets. So particularly when we look at connected devices such as the DVRs, the webcams, and other devices that were part of the Mirai botnet, where we have a situation that resulted in the harnessing of these devices and those devices being turned against private sector entities. In this instance, in the Mirai attack, it could have easily been turned against a hospital. It could have been turned against a piece of critical infrastructure, an electric grid. So I think it's critical that when we think about IoT security issues, we keep this problem of reciprocal security vulnerability in mind, meaning that the problems of the device vulnerability in the private sector inherently impact issues that we all face as citizens and our physical safety as citizens. Because whether it is someone seeking to have some fun with manipulating a device, whether it's a webcam or a toy, or it is a nation state trying to hurt our citizens in a type of attack, this problem of the code that exists in these devices being vulnerable, that's the root of this problem. So playing off of that, I'd also like to highlight the important efforts of the Department of Justice and companies such as Microsoft in working to take down botnets. So the national security threat is not a hypothetical one. IoT botnets present a real and urgent danger to the possibility of severe physical and other injuries resulting from security vulnerability. Playing off of that, I wanted to also elaborate on some perhaps pedantic, but I think legally important distinctions that were perhaps not crystallized in the first rounds of testimony. So just as an aside, there was an incident with the Hello Barbie doll in 2015 where Mattel needed to roll out fixes because there was a compromise of that doll. The concepts of privacy and security are distinct, and it's very important from a legal standpoint, in my opinion, working on these issues, to keep as close to the technical definitions of these constructs as we can, because it allows for teasing apart a whole host of complicated legal and regulatory questions. So what do I mean? Privacy generally relates to the relationship between an individual, a consumer in this case, and the entity that's collecting information. Those privacy questions are complex. They have a set of understood promises that vary. But security, we're talking about how systems function. So there are baselines of care that exist and are uniform across systems that are reasonably secure. There is a known set of categories of attacks, vulnerabilities that should not be present in any product or service, full stop. That's the baseline of reasonable security. And it's this baseline of reasonable security that is the theme and the approach that's emerging across agencies in the government. We see the discussion of security flaws, failures, malfunctions coming through in the reasoning of the Copyright Office for granting a security research exemption in 2015. The FTC uses the language of reasonable security. The FDA has already issued recalls solely for security failures. And security isn't just about data control. Security has three types of harms. The first is the confidentiality harm that we often think about with the rampant data breaches that we see. But there are two other categories. The second category is the category of integrity harms, and that presents the core category of malfunctions, manipulations, physical harms that I believe that the Commission is best suited to address. So it goes to the question of whether the code in a device can be manipulated to cause harm in some way. That is functionally a malfunction. So whether a chainsaw can't turn off because the switch doesn't work, or whether a chainsaw can't turn off because a remote attacker has used a code flaw to keep the chainsaw on, the harm to the consumer is the same. And so, as a conceptual matter, I would urge the Commission to look at the consumer harm and work backwards and think about expanding the existing rules that exist for various product categories to incorporate an explicit reasonable security requirement. And this will cause a workable baseline and a dramatic shift and improvement in raising the floor of security that already exists, hopefully, in various products. So in addition to this floor of security, because innovation requires flexibility, the industry-specific baselines above that floor of reasonable security certainly should and will be discussed by particular industries in a collaborative way to develop the best practices and the models for implementing these baselines of security. But the baselines should be a universal construct of reasonableness. Next, I wanted to mention that the Internet of Things is really not new. The first internet-connected toaster was connected in 1990. So while this is a field that's new to us as attorneys, technologically speaking, there's a robust security community that's been thinking about these issues for a very long time. And engaging with the security community and benefiting from their perspective on the repeat types of attacks, whether the attack happens on a PC or on a mobile phone, which, footnote, is an IoT device, or happens on DVR, the type of attack repeats itself. And so there is a corpus of known mitigations and some of which are really straightforward, and I think we'll hear more from the security experts on the panel about what those look like, so I'll stick to the law. In my last minute, I wanted to highlight the fact that international standards already exist and provide a process-based approach for addressing the questions that we're talking about here today. For example, I would point the Commission to ISO 29147 and ISO 30111, both of which advise companies on how to accept external reports of security malfunctions. So there should be a link on their website. There should be an easy way for a researcher or a consumer to interact to report the malfunction. Most IoT companies, unfortunately, still do not comply with that baseline of communication with consumers that's set forth by those two ISO standards. And I'd be happy to put the Commission in touch with the author, the lead author of one of those standards, who's a security researcher. Finally, another strategy could be called cat fooding. So some of the most sophisticated companies who are concerned about security bring their products and encourage the world of security researchers to interact with them and look for flaws. That is what I call the notion of cat fooding, putting out the food and letting all the cats come and attack the thing. That's something that I'd be happy to facilitate for various industries as well, and there are lots of other ideas that we could work forward on to improve security.
Thank you very much, Mr. Wallace.
Thank you very much. On behalf of Consumers Union, the policy and advocacy arm of Consumer Reports, thank you for the opportunity to testify, and I just want to say that we are thrilled that this hearing is happening, and we have found the discussion so far productive, and so we're very glad to be here and to be a part of it. Internet-connected devices are becoming available in the marketplace at a rapid rate, and they present new safety challenges that are not adequately addressed by current standards or CPSC tools or resources. We urge the CPSC, other government agencies, and all stakeholders to live up to a pro-consumer vision for the Internet of Things, or IoT. Companies should ensure that product safety is paramount at all times, including prior to sale or use, after a product has already reached consumers, and when products may need to receive over-the-air updates or be repaired or recalled. Companies also need to place consumers first, including by ensuring updatability for security and functionality, transparency and appropriate notice to consumers, secure interoperability with other products, and a consumer's ownership and control of products, including their ability to use the repair provider of their choice, otherwise known as the right to repair. For its part, the CPSC should encourage companies and industries to put consumers first and take enforcement action against those that violate the law and put consumers at risk. Just like today, the CPSC should set a high bar for safety culture, safety standards, and responses to safety issues. It should repeatedly and consistently urge companies and industries to reach that high bar, both through public and private advocacy, and require them to do so when they do not act on their own. Specifically, to carry out its safety mission when it comes to addressing hazards that can be created by Internet connectivity or that are otherwise IoT related, the CPSC should first use a framework with 3 categories, which Don Huber mentioned earlier, to assess and address safety hazards involving Internet-connected products. Now I'm going to get into our idea for these categories in a little bit more detail. For consumers to be assured that the products they purchase or use are safe, all Internet-connected devices should be subject to minimum safety standards. The scrutiny applied to products and the detail of the requirements in a standard, however, may vary based on the type of product involved. We recommend dividing products into 3 broad categories, including the following. 1, safety products, or those whose primary purpose is ensuring consumer safety. These products, such as baby monitors, electrical safety switches, fire extinguishers, and residential fire sprinklers, smoke and carbon monoxide alarms, these should receive separate, specific scrutiny and requirements to protect against compromise or malfunction. 2, products that could foreseeably cause death, serious illness, or severe personal injury if improperly designed or compromised. These products, including fireplaces, furnaces, generators, lawnmowers, off-highway vehicles, ovens, ranges, and other similarly hazardous products, as well as any product connected to them via the Internet that, if compromised itself, could compromise the safety of any of the original products. should receive significant scrutiny and be subject to requirements appropriate to help prevent hazards. 3, all other products. While a product in this category should still, of course, be safe, secure, and free of defects, its lower potential risk may allow for less initial scrutiny until its susceptibility to creating a serious hazard is identified. Until that time, a product in this category could be subject to higher level, less detailed requirements related to hazards presented through internet connectivity. In overseeing the safety of some 15,000 types of products, the CPSC is charged with addressing a wide range of safety hazards to consumers, as you all know quite well. We note that safety and privacy considerations can be closely intertwined, as has been mentioned multiple times today. And inadequate or failed security measures can all too foreseeably lead to safety hazards for consumers. Moreover, software and electronics system flaws can cause data security and privacy-related harms at the same time they pose a safety hazard that must be remedied under the Consumer Product Safety Act. It's not necessarily one or the other. Second, the CPSC should ensure companies play their critical role in the safety of IoT devices, and do so vigorously. Under voluntary standards and the law, companies throughout the supply chain must be responsible for the safety of internet-connected consumer products. But as they have with other products, they will sometimes fail to do so. The CPSC should therefore ensure that companies design and produce connected products with safety hazards minimized, and establish any voluntary standards necessary to adequately reduce the risk of consumer injury and create a level playing field for an industry. The CPSC should also put in place mandatory standards where safety issues associated with connectivity apply across industries or where industries do not move forward on their own to adequately protect consumers. In fact, there is a distinct danger in exclusively leaving it up to individual industries to provide consumers a minimum level of protection from IoT-related safety hazards, given the complexity and the ubiquity of associated risks. While both voluntary and mandatory standards have roles to play in protecting consumer safety, voluntary standards may come first. The CPSC should help ensure that voluntary standards are developed through a consensus process with strong requirements for transparency, balance, and fairness, and with a balance of representatives from different parts of the supply chain, consumers, safety groups, academics, standards development organizations, the CPSC, and other relevant government agencies. Third, independent of company efforts, the CPSC has an indispensable role, and it should be active, engaged, and properly resourced in carrying out that role. When companies' products do not live up to the safety required of them, recalls should happen as quickly, as completely, and as easily for consumers as possible. The CPSC should foster effective recalls and recall communications involving these products, in keeping with previous recommendations we have made regarding recall effectiveness. Further, the CPSC should expand its approach when considering defects with regard to IoT devices. A safety defect may not necessarily be part of the product that harms a consumer directly, but rather is a part of a system or the code of a different product to which the end product is connected. For example, a safety defect might be the way a product's software is programmed, even if it is a second different product connected to the first that injures a consumer. At the same time they may present new defects, IoT devices could present major new opportunities for improving recall effectiveness. There is the potential for manufacturers to equip more consumer products with the ability to be bricked to protect consumers in especially hazardous conditions. Also, increased internet connectivity could greatly enhance direct notification to consumers of safety issues, as has been discussed. We urge the CPSC to encourage and ultimately require this kind of notification in a standard, straightforward format that gets consumers to take action and protect against the improper use of over-the-air updates to conceal rather than address safety issues. In carrying out its work, we recommend that the CPSC collaborate closely with other U.S. agencies and, as appropriate, international safety authorities. We recommend that relevant U.S. agencies, including, in particular, NHTSA, the FDA, the FTC, and NIST, reach a keen understanding of each other's work and identify the ways in which collaboration would yield consumer benefits. Internationally, it is important for the CPSC to exchange information about product hazards and to identify ways to cooperate to improve consumer safety. Such cooperation, however, should not limit the agency's work on behalf of consumers, but instead should help to make universal the most protective standards and avoid setting standards at the lowest common denominator. The CPSC plays an indispensable role in protecting U.S. consumers despite lacking many of the tools and resources it would need to carry out all that it is capable of doing. As has been the case before, the CPSC will need new expertise and resources to effectively protect the public as the marketplace changes, including to ensure that the agency can adequately evaluate and determine appropriate action to address safety hazards related to software and other non-traditional areas of product safety activity. We recommend that the Commission seek an increase in the CPSC budget to expand staff skills in these areas, and also consider adding additional expertise in electronics and automation. In conclusion, thank you very much for holding this hearing today. As IoT devices become more prevalent in the marketplace, we look forward to working with the agency and with all stakeholders to help keep consumers safe.
Thank you very much. Mr. Stanislav?
My name is Mark Stanislav. I am currently the Director of Application Security at Duo Security. Over the past 15 years, I've worked in a variety of IT and information security roles. I've presented internationally at technology conferences about IoT security and shared my research with the U.S. Copyright Office and FTC, usually to help bring to light the vital role that security researchers play in actually protecting consumers through our research. I began doing security research on IoT devices to protect myself as a consumer. In June 2013, I noticed a device on my home network using out-of-date, insecure technologies that I wouldn't have expected. Upon investigation, this device turned out to be my home's IoT camera that I had placed in my living room 6 months before. This led me to uncover many critical flaws with that unsafe device, and I started a multiple-year journey researching IoT. My goal has been to help mature the IoT industry through published research, public policy work, and initiatives intended to drive advocacy for more secure IoT devices. From June 2013 through February 2016, I performed IoT security research projects against 13 devices, including web cameras, baby monitors, smart toys, and a child smartwatch. These devices ranged in price from $55 to $260. Representing a variety of vendors and retailers, from well-known brands at big box stores to new startups via crowdfunding campaigns. This work led to finding and getting fixed numerous critical security issues. One such device was an unsafe connected children's toy, this one right here, that received investment through a crowdfunding service. This device intended to allow parents, family members, and authorized users to send audio recordings to children to the connected toy via a mobile application, and it allowed children to reply back using the toy. As a backer for this device through the crowdfunding service, I received a pre-retail version, and within a weekend, I had found critical security and privacy issues that rendered the device unsafe for children to use. I had access to every parental account holder's full name, their email address, children's details, including, if uploaded, a photo, their full name, date of birth. These allowed me ultimately to then use another security issue in my testing against my own accounts to send a message without parental intervention to any child's toy within that entire ecosystem. This is something that parents did not have to agree to. There was no approval process required for that attack. Basically, the unsafe toy could have been abused by anyone, child predators, to talk anonymously over the internet to children with no knowledge of the parent if they were not very on top of the situation. In another case, an unsafe $200 IoT baby monitor had a simple web service vulnerability that could have allowed an attacker to gain full access to any customer's camera. This access would grant on-demand audio and video streaming and allow the physical adjustment of the camera's position in the room. Again, a child predator could use this unsafe device to watch children, talk to them in their bedrooms. This has already happened. If you've seen news stories over the years, that this is not, a TV show, this is real life. We see these things unfortunately occur. As a final example of my research, an unsafe children's smartwatch was offered through a crowdfunding campaign that allowed parents to keep track of their child's location via a mobile application. By reviewing this mobile application and the vendor's service platform, I determined attackers could add themselves to a family's authorized users and review the history of those people's locations and actively track any family member, either their phone if they had the application or the smartwatch of the child. These results are frightening and demonstrate significant safety deficits, not only because of the potential consequences for flaws for children's safety and privacy, but also because of how easy these flaws were for a security researcher to find with only basic safety research. In February 2014, I co-founded an initiative called Build It Securely to help create opportunities for IoT vendors to leverage pro bono professional security researchers to have code safety of their devices reviewed prior to going to the market with release. At its peak, Build It Securely acted as a resource for 16 vendors and organizations to connect more easily with researchers, and perhaps more importantly, signaled that immediate action needed to be taken to improve the safety of the Internet of Things. During my time as a security consultant, I was retained by numerous technology firms with focuses in home automation, medical device manufacturing, and smart toys. In this capacity, I was able to train staff in the risk facing their connected devices, advise on secure design decisions to make products safer, and to help verify that the choices were made were sound with regard to security and privacy concerns. It's no stretch to say that a typical IoT device may have a dozen or more technologies, all working in harmony to provide value. Because of the complex supply chain, including software libraries, third-party web services, hardware components, and the contractors doing the work, for any IoT device, vendors are often shifting responsibility upstream to those vendors, to the component providers, in order to secure their piece of the equation. Unfortunately, this does not usually happen. It's extremely common to see IoT devices leveraging unsafe cookie-cutter hardware components due to their low cost and ease of implementation. Often these components have firmware inside of them that is woefully out of date, presenting security risks from weak and insecure protocols, all the way to critically vulnerable software that has had an update for years prior to release. The commodity chipsets being produced in places like Taiwan and China will rarely have the business justification to patch these unsafe components. So even when issues are found, users of the same chips will be just as vulnerable. In my own research, 2 different devices from 2 different manufacturers that I tested 2 years apart had the same firmware with the same vulnerabilities, further lending insight into the supply chain risks of IoT vendors. Common firmware that may be used by vendors can have shared hard-coded or default passwords that should have been removed or changed. This sort of oversight leads to dangerous botnets like Mirai, Reaper, Hajime, remotely controlled networks of hundreds of thousands of unsafe consumer IoT devices that are used by criminals to attack targets such as websites, hospitals, or critical infrastructure. Mirai comprise mostly of consumer IoT cameras and home network routers, abusing around 60 common username and password combinations. This botnet triggered the largest distributed denial of service attack in history as of 2016. A number of focuses would dramatically improve the safety of IoT consumer products, including a bill of materials for every device, mandatory security assessments, end-of-life dates, service ecosystem transparency, component vendor attestation of security, a security score on packaging, and required technical criteria. As a security professional, I cannot tell by looking at a box, seeing a price, or knowing the manufacturer if a device is secure or not. Consumers are in an impossible situation to understand if they are at risk by any of these devices. IoT devices are often sold with very limited detail about their technical security beyond buzzwords like military-grade security. That sound great for marketing, but really don't mean a whole lot in practice, unfortunately. They certainly do not mean these devices are safe for consumers. Only safety guidelines from a regulating body, coupled with industry security expertise, can improve the truthfulness of safety claims and ensure that devices are reasonably secure when they are being sold to consumers. The security research community has provided a wealth of testing over the years, and one recurring theme is the trivial nature with which abuse is able to occur. I do not agree with the supposition that we are unable to come up with guidance, Indeed, it already exists in many forms. What we do not have is legal enforcement of the technical security guidelines that could resolve what should be non-existent types of bugs impacting these powerful devices. For these reasons, baselines of consumer safety protection are needed through CPSC rulemaking. I urge the CPSC to adopt baselines of IoT consumer safety, product safety in line with the suggestions I have previously listed. I appreciate the opportunity to share my experiences with you all today. Look forward to a more safety-conscious future for the Internet of Things. Thank you very much.
Thank you very much. Ms. Kang?
Very much for the opportunity to testify, and also thank you very much for holding this hearing on interdisciplinary analyses of IoT. I cannot overemphasize how important it is to understand the technical, legal, and market frameworks of IoT to truly achieve the best standard of consumer protection possible. My name is Sonny King. I am the International Consumer Counsel at the Electronic Privacy Information Center, also known as EPIC. I'm here to say that privacy and security are integral to consumer safety. Today, the Internet of Things are the weakest link to privacy and security vulnerabilities in consumer products. IoT devices track personal data by seamlessly integrating into the lifestyles and activities of consumers. They blend into everyday objects without being noticeable as an IoT device. Thus, the ubiquity of IoT sensors and their amassment of granular data pose significant privacy concerns that could very easily threaten physical danger. The Consumer Product Safety Commission has a responsibility to protect consumers from the risk created by these devices. Holding a hearing in 2018 to discuss the consumer safety of IoT without addressing privacy and security hazards would be akin to holding a hearing in the last century about kitchen appliances without addressing the risk that an appliance might catch fire from inadequate wiring. Devices which put sensitive data of consumers at risk pose real threats to consumers, and this is why there is an urgent need for increased transparency and accountability by vendors. The Electronic Privacy Information Center is a public interest research center established in 1994 to focus public attention on emerging privacy and civil liberties issues. Last fall, EPIC and a coalition of consumer groups wrote to the CPSC urging the Commission to recall the Google Home Mini. The device had a manufacturing defect that allowed Google to intercept and record private conversations in homes without the knowledge or the explicit consent of the consumer. We brought the complaint to the CPSC and not the FTC precisely because this was a design defect of the device intended for the consumer marketplace, which created a specific privacy, security, and a safety risk to consumers. We received a response from the acting chairman stating that the CPSC's authority will not generally extend to situations solely related to consumer privacy or data security that do not pose a risk of physical injury or illness or property damage. We believe that this assessment is outdated and reflects a lack of understanding about the IoT and the new complex technical threats facing the consumers today. As the renowned expert on security Bruce Snyder has said, the Internet is dangerous, and the IoT gives it not just eyes and ears, but also hands and feet. Security vulnerabilities, exploits, and attacks that once affected only bits and bytes now affect flesh and blood. If the CPSC ignores these dangers posed by IoT, it will be ignoring its congressional mandate to protect consumers. The consumer hazards created by IoT devices extend far beyond tripping or falling, laceration, or contusion contemplated by the federal notice for this hearing. Poorly secured IoT devices are used for botnets that launch network attacks that can cause millions of dollars in property damage and have lasting and devastating impacts on real people and their lives. Hackers could conceivably exploit vulnerabilities on your smart refrigerator or smartwatch to carry out a denial of service attack against a network of a whole city or a hospital. In the past few months alone, there have been several such attacks. A ransomware attack known as SamSam took down the entire municipality of Farmington, New Mexico, and 2 hospitals by exploiting the vulnerabilities in IoT devices nearby. The city of Atlanta spent $2.6 million to recover from a ransomware attack that impacted municipal functions, including police departments and judicial systems. It would therefore defy reason to say that unsecured IoT devices do not harm consumers physically or directly. Privacy and security standards and hazards should be regulated, especially in the manufacturing and design process of these consumer products. Companies have little incentive to maintain strong standards without regulation and oversight to push them to do so, and consumers do not have enough information themselves to evaluate the privacy and security aspects of these products themselves. Companies are aware of this information asymmetry, and they take advantage of it by providing very little information on the packages. And consumers have alarming harms and implications, especially for toys that target children's data and internet-connected home systems like smoke detectors and security cameras. Therefore, manufacturers and not consumers must bear the responsibility to ensure the security of their products. We particularly agree with an international standard on this provided by the UK government in their assessment that there is a need to move away from placing the burden on consumers to securely configure the devices and instead ensure that a strong security is built into the design. Current voluntary standards are lax. Current safety regulations are outdated. They're not adequate to address the security hazards of IoT devices. The CPSC should establish mandatory privacy and security baselines and require certification to these standards before IoT devices are allowed into the market stream for consumer use. The Code of Practices proposed by the UK government serves as a useful framework for security standards in IoT. In particular, manufacturers should adopt the following: no default passwords, implement a vulnerability disclosure policy, keep software updated, securely store credentials and security-sensitive data, communicate securely and encrypt data, minimize exposed attack surfaces, ensure software integrity, ensure data protection, make systems resilient to outages, and make it easy for consumers to delete and rectify personal data and validate any input data. I believe that this guidance necessitates important privacy and security by design. If the CPSC implements this code of practice and also further guidances and rulemaking on IoT devices, it will shift the responsibility of product safety back to manufacturers where it rightfully belongs. I thank the Commission for the opportunity to testify and look forward to working together on this critical consumer safety issue.
Thank you all very much, and again, thank you for your testimony today. We will now begin our round of questions from the dais here. Mr. Wallace, first of all, let me thank you for being here, but also your suggestion about more money for our budget, if only that were up to us. So I would encourage all of you, and your point is well made. In order for us to get above the baseline of what we do day to day and to be able to address emerging hazards, whether it's e-commerce or the IoT or any other endeavor, increased funding is necessary, and we will be doing that as the appropriation time is appropriate. But I appreciate those comments, and again, if we only had control over that situation, our lives would certainly be easier. I wanted to just mention to you, your testimony talks about a tiered approach to IoT products. You mentioned safety products, ones that could really cause serious injury if defective, and then all other products. So are you recommending that each group of those products would have different set of standards, or maybe you could elaborate on that a little bit more?
Sure, I'm happy to. So what we're envisioning with these categories, it's not necessarily tiers. It's more of a different way of approaching different categories of products. We do think, though, that a different level of scrutiny and a different types of requirements could be applied to these 3 categories.
Thank you. Dr. Matt Wishon, thank you for your excellent testimony as well. I just wanted to, because it really is contrary to what we heard this morning about children's safety, but the FBI warning that was that you mentioned, and I see it's in your footnotes, but could you just speak to that a little bit? Is there anything about actual product safety, or is it all on the security and the on that side of the issue?
The FBI makes reference to physical safety of children.
Okay, but there's no frame. Well, we can get
So
the
notice, actually I have it pulled up in front of me. Consumer notice: internet connected toys could present privacy and contact concerns. So it's the contact concerns that led to the statement in this press release about the physical safety of children. So it's the type of leveraging of obtained credentials, for example, such as was described with the children's toy, that could lead to contact and follow-on physical harm. So the harms with IoT devices and security are not simply the initial contact, but it's the leveraging of that flaw in the product in furtherance of a more dramatic, serious attack. So each compromised DVR won't take down a hospital network, but 100,000 compromised DVRs will take down a hospital network and potentially kill patients.
Thank you for that. Most of our data collection involves injuries, personal injuries as related to a consumer product. Can you suggest to us any way, an effective way for us to be tracking this IoT-related the data that would result from that?
So I haven't had an opportunity to look at the exact data framing that you have up on the consumer protection site, but certainly the types of additional categories that we heard this morning about getting to the bottom of the flaw and how the flaw resulted, greater granularity is certainly possible. The types of information that's missing from an average consumer disclosure about the life cycle of a product, the degree to which the security has been tested, whether it's been certified by an independent auditor, what kinds of internal components exist, what code libraries are incorporated by reference. All of these technical pieces of information provide a critical component of being able to deduce the level of security that exists as a baseline in a particular product. So there certainly is a straightforward path to updating those categories of data collection that I'd be happy to comment further on in follow-up commentary.
Thank you very much. I appreciate that. Mr. Stanislav, your testimony talks about an ecosystem in terms of many components. And so this is obviously related to what we talked about this morning, but do you see each one of those components being regulated, or are we talking about regulation and standards to the, relative to the entire ecosystem?
Yeah, so in my proposal, I mentioned component vendor attestation of security. One of the things that I've seen, and the circle I have is working with so many vendors, including vendors on this table. After I find issues, I work with them to resolve those issues. Very often, they are trusting the third parties that they are buying products from, the software developers they are hiring, to be the ones doing due diligence and performing security assessment and owning that part of the supply chain. That unfortunately does not happen. And without a forcing function there to get those parties to have to do so, other than kind of legalese of their own kind of creation and contract work, there's just not a lot of footing for these companies to make that a kind of standing thing. So I think there's that piece, and then the secondary piece being, an individual component into itself in a vacuum may be secure. The connection of more than one component often is where resulting security issues come from. So I think you do your best upstream with the component vendors, with the software developers, and make them own that responsibility. And then the ultimate, product on the shelf, that should be a total sense of ecosystem from the manufacturer.
Thank you. And in those components that you're talking about, is there more of a vulnerability in any one of those components, or is the risk essentially the same regardless of the component?
Yeah, great question. Going back to categorization, certainly, something like an oven would have perhaps different kind of components that would be more risky than other things. A lot of the security issues I spoke about today, and indeed most of the security issues I found either working in a professional capacity or as a researcher, very often they are simple website vulnerabilities. The same reason we see data theft from websites on the internet are the same kinds of bugs introduced. Most of these devices are little, think of your Android or iPhone in your pocket. These computers inside are not much different. They run the same operating systems, the same chipsets, the same hardware. It's really the ecosystem on top of that, the software that's connecting you to the internet, the software connecting you to a mobile phone, where many of those issues come into play. Second order issues in going back to network protocols, Wi-Fi, Bluetooth, Zigbee, Z-Wave. These each have the same kind of cryptographic, the end-to-end security of confidentiality that consumers know on HTTPS websites, for instance. That is something that is also usually missing. And so if you are able to be co-tenant on a network like a guest Wi-Fi, these devices in most cases are actually sending information completely insecurely, including audio, video, images.
Thank you very much. And if I could ask, and any one of the four panelists, you feel free to chime in, but because we've heard this as a theme, we need to, as an agency, to be looking at this. And so I'd be interested to hear, and Mr. Wallace, this has to do a bit with your suggestion about increasing our funding and taking on different types of, increasing our ability to do this. I'd like to hear from any of you, what kind of technical resources and experts do you think we need to bring on to be able to adequately address our role in this problem? Or, I say in this problem, in these potential problems, because we've heard in all three panels there are some real benefits from having this interconnected technology. Dr. Matt Wishon?
So I think by starting with a baseline of a reasonable security requirement across the board, you facilitate the private sector to help you uncover flaws. Then, with the hiring of maybe 1 to 2 security researchers in your labs where you test so many other products for safety concerns, you would have a steady stream of discoveries that would lead to recalls, which would then put the industries, plural, on notice of the types of problems that exist that they need to address in an expedited manner. So I think even 1 to 2 new staffers would make a tremendous difference.
Thank you. Mr. Wallace, anything to add?
Nothing to add. I think that makes a whole lot of sense.
Mr. Stanislav?
I'm in agreement as well.
Thank you. Ms. Kang?
I would just add really quickly that there might be a need for policy analysts and counsel to consider different international approaches to IoT security and privacy and to come to the best conclusion of the baseline standards to adopt.
Very good. I appreciate all of your input. Commissioner Adler.
Thank you very much, Madam Chairman. And again, I want to express my appreciation to you for all the support you've given to increase the agency's budget. I think that's an act of courage these days, and it's been very effective, and I, for one, appreciate it. Dr. Matt Wishon, I'm intrigued by somebody who has the skill to be a professor of law and to be a professor of computer science simultaneously. I can think of few cognitive challenges greater than that, so I really admire your ability to speak to that. So one of the things I wanted to ask you about, because it made a lot of sense to me in the abstract, but I'm wondering if you could make it a little bit more concrete, and that's when you said as a guiding principle, look to the physical harm or the consumer harm and work backwards. Could you give me sort of at least one example of what you have in mind of what a consumer harm would look like and how we would work backwards from that?
Sure. So let's take an IoT stroller.
Mm-hmm.
Some strollers now allow for independent movement, for jogging, etc. So if a stroller harms the infant inside the stroller, something has gone wrong. That's a flaw or a malfunction. Functionally, whether that flaw has arisen from a sharp plastic component or an improperly coded piece of software, the child is still harmed. And so there's been a cognizable physical injury that can be identified as a product flaw or malfunction. And so that's kind of why I would suggest putting in this baseline of reasonable care with respect to the security of code across the board in all products.
That sounds eminently reasonable to me. I did just want to make a quick comment, and if you have a comment of your own, and that is your sense that we should make product liability complementary to product safety. One of the things that makes me nervous is anytime we talk about reforming product liability, what we're typically doing is saying limit product liability. And I'm wondering, do you see a threat there, or is that just a general notion that you have?
It is not my intent to limit product liability in any way. This is intended, in my mind, to be a complementary approach, which creates a baseline of care that, if anything, should ease the burden on seriously harmed plaintiffs in being able to demonstrate that there has been a harm because of the software at issue. And in that way, there will be a, hopefully, facilitation of bringing meritorious claims before the courts, particularly in light of the Supreme Court's willingness to look at not only physical injury, but non-pecuniary data injuries in the Spokeo case, signaling their willingness to do that. This would be a constant approach, creating a baseline that's intended to work in a complementary way to advance the evolution of tort.
Is it Dr. Stanislav or Mr. Stanislav?
No, but I have my doctoral submission in, so possibly soon, I hope.
Doctor, okay. Well, I'm comfortable calling you doctor. One of the things you talked about is a principle is to have a bill of material for every internet-connected device. And I'm not certain I understood precisely what you meant by that concept, but if that were the case, then how do you get companies to participate when they're worried about trade secrets and proprietary information? So if you could explain that, I'd appreciate it.
I think one of the most shocking things in my career has been when you ask an organization, how is this device built? They have to go talk to 37 people and call 8 different countries to figure that answer out. And so simple things, reasonably a lot of the software in both of these devices, in fact, and many others, use a lot of open source components. Free software, widely distributed, shared ecosystem of access to everyone. And what happens is when one security flaw is found in one piece of software, if I built that software, one device or the devices I put into, the software I put in that devices are affected. In open source, you might have tens of thousands of different devices with different manufacturers. And one of the things we see time and time again, one of the baby monitors that I looked at in my research of 9 different baby monitors actually included a component, I believe it's 2 to 3 years later, that was as critical of a security issue as you can find. It's the highest score in the scoring mechanism that we use in the industry. And that issue had a patch for over 2 years. There was no reason it should have shipped in that device ever. There was no update for my device once I bought that baby monitor, and I believe it was a $260 baby monitor. So just knowing what is inside of a device gives both consumers, if this was information, for instance, indexed in a common place on a manufacturer's website, or security professionals like myself that can index across many manufacturers, I can reduce harm immediately. If I find a security issue in one library, I can then tell all of those manufacturers in one shot that they're also impacted.
It sounds like a great idea. Again, my concern is how do you get people to do that? It's a great idea, but what incentive is there? Is that if I do that, then people will buy my technology, or if I do that, if I don't do that, the government will come after me?
This is actually an interesting topic that the RSA Security Conference just occurred in San Francisco about a month ago, and the Computer Emergency Response Team CERT-CC with Carnegie Mellon and DHS, this was a topic of discussion that all of the vendors in the room said, I want to know if an issue affects my product. And the question is, well, how do we tell you if we don't know what's in your product? So I think there is buy-in to doing this because, again, if it's a proprietary feature, there is no index needed because no one else has that. If it's an open component that is shared into the world, then that's actually a problem that CERT and NTIA and some other organizations are trying to figure out how do we do that multi-party vendor disclosure if I, as a researcher, find an issue. So definitely a very hot topic right now.
Ms. King, you mentioned UK's Code of Practice, and there are 13 rules in that Code of Practice. Do you have any sense of how well that's worked? Is that something we could look to for guidance here, or has it had a mixed bag? Can you tell us what the level of success has been?
I think that the rules are recent, but they do provide a good foundation to self-regulatory rules and industry compliance with these rules to increase privacy and security standards. What these rules focus on is the lack of self-regulatory guidelines that directly address and improve privacy and security, and also the information asymmetry that consumers face when they're burdened to assess the safety of these products on their own, despite not being experts or despite not knowing what happens behind the data collection and who the third parties are who receive the data collection from the IoT devices. Another big point about these UK guidelines is transparency and accountability for manufacturers. Manufacturers often hide behind privacy policies, which again do not aid the understanding of consumers to make decisions on products. And what these guidelines suggest is for them to adopt privacy by design standards and privacy and security enhancing technologies so that the data collection is minimized and that there are built-in security systems.
Thank you very much. Mr. Wallace, you listed the three broad categories of products for purposes of priority, and I certainly understand safety devices, but I guess my question is, how do you distinguish between the substantial imminent hazard and all other products, and when would we do that? Would we do that because we got 15,000 product categories that we worry about. I assume you're not suggesting we go through them before we have problems, so at what point would we do that?
No, we're certainly not suggesting that, and it's a challenge. It is. I mean, in discussing these categories, we recognize that that's going to be a serious challenge, and that I think it's mostly designed as a way to approach the subject and a lens through which the Commission can think about IoT-related hazards.
Dr. Matt Wishon, I guess this is my last question, and that is, with all of these new entrants coming into the market with connected devices, some of whom, as I say, never heard of product safety, never heard of these organizations, how do we guarantee that the new entrants who may be less than technically competent meet these standards? You've got consensus standards, you've got guidelines, you've got mandatory standards. When do we decide which of those we're going to use?
So I think that that's the beauty of a reasonableness standard. And then the interpretation of that reasonableness standard can subsequently be built out by the Commission or by working groups to mean different things in different contexts. But it ensures a floor below which new entrants won't fall. In every industry, there are certain baselines of care. In securities regulation, if you are trying to do a public offering, you have to learn the securities laws. If you're looking for investors, you have to engage in reasonable disclosure practices with respect to that. So this is a situation where the company is choosing to make a product that assumes a higher degree of risk because of the connectivity. If you'd like to make a not connected product, then you don't need to worry about this extra assumed risk. So it's inherent in the business model choice. And especially once there's a baseline of care, there'll be resources that the Commission and the private sector will build out around this baseline of care. And so it will be a more market-driven approach that will emerge, but in particular, it will reward the companies that act well with respect to consumer care and engage with good security. And so the market will reward them for their investments in security. Right now, the companies that are not investing reasonably in security are hiding behind the lack of disclosure. And that's costing the companies that are investing in security the benefit of the marketing nudge and the recognition by the consumer marketplace that these are safer products.
Thank you. Commissioner Robinson.
We heard some testimony this morning that I sort of glommed onto just because it's something tangible, and I feel like it might be low-hanging fruit that we might be able to do something about fairly quickly, and that is F963. The testimony, basically, I think all of you were here when we heard from the toy industry, and basically it was that there isn't any safety issue with respect to Internet of Things when it comes to toys. You can't make a toy dangerous through an IoT device, and that COPPA covers any privacy issues, so we should just leave F963 alone because it's sufficient, even though we couldn't recall products if there were problems. But I would just like to hear any comments that you have. We can start with you, Dr. Magician.
So with respect to the COPPA discussion, it's the FTC's position, in my understanding, that there is a clear role for the Commission to get involved in this space, and that the concerns that the FTC enforces under COPPA do not map to the same types of product safety concerns that the Commission would address in engaging with an IoT rulemaking guidance, et cetera. So my understanding, admittedly limited, of F963 is that one of the core ideas is the question of reasonably foreseeable abuse of the toys. And so making a statement that reasonably foreseeable abuse includes abuse that happens through security flaws, malfunctions, vulnerabilities. That could be a succinct way to hook the F963 approach into these questions of IoT safety.
So would it be your position that we could do that without amending F963?
So whatever the most effective method that the Commission would determine to be to convey the idea that security flaws constitute reasonably foreseeable abuse. Whether that's amending
It's not abuse, it's misuse. So that's different.
Misuse would work too. I may be looking at an older document. So misuse would work too. So it's the idea of changing the code, being able to manipulate the code or manipulate the functionality of a product in a way that could potentially lead to harm.
Do any of the other panelists have any opinion on whether we need to do something with 963 if we were going to address the IoT issues, or if it's sufficient right now?
Yes. We have such respect for the work that has gone on to make F963 as thorough as it is today. We also think that it's far too soon to say that there aren't safety risks that need to be considered related to the Internet of Things. We think that, you know, it's often noted that one of the benefits, or one of the ways in which the voluntary standards process can be particularly productive, is in responding quickly as the marketplace changes. And so F963 should do that as well. And, you know, when thinking about setting a floor, for example, for reasonable security, certainly the toy industry, as with other industries, should be prepared and be enthusiastic about updating their standards appropriately.
But the bottom line is it is too soon.
It's too soon to say.
I understand.
Yeah.
So as long as I'm talking to you, let me ask you another question. Early on in my tenure as a commissioner, I visited Consumers Union, and I discovered, to my surprise, that you guys keep data as well. And we even ended up finding a way that we could coordinate getting your data. But do you know if Consumers Union is gathering any data with respect to incidents related to IoT?
So we, in the process of preparing for this hearing, we actually took a dive into what we have available and what we
Good,
can
I'm glad I asked.
Yeah, and what we can discern from the CPSC's data. And at this point in time, we are, you know, Don Huber addressed this a little bit earlier, but we are finding that there are some data gaps that are going to be really important to fill, and it's going to be. You know, we understand the challenges that exist when adding data fields, but at the same time, to be able to adequately address IoT-related hazards, it's going to be really important to know whether a hazard is related to IoT and Internet connectivity.
So as we sit here today, do any of you know of any incidents where hacking or breach of security has actually led to a product becoming dangerous. That's a product that's within our jurisdiction, which obviously doesn't include automobiles. But as we sit here today, do you know of any incidents that have occurred?
The best example I can give without harm being done was a literal Wi-Fi enabled rifle. That was the subject.
That sounds dangerous.
Yeah, it was the subject of a, I believe, DEF CON presentation perhaps 3 years ago now. And there were a number of security deficits of that as well, in which they could actually, there's basically a mobile app that you can target your thing through the camera of the phone, and it would actually, it was able to be reprogrammed to basically veer the bullet.
Unfortunately,
So-
guns aren't under our jurisdiction.
Yeah, well.
They're explicitly excluded. Does anybody know of any other incidents?
Sure. So we can certainly submit a whole list, but for example,
Okay.
internet-connected ovens have been manipulated.
Okay.
So no one, fortunately, died.
Okay.
But the
Okay,
capability
that's
to
very helpful.
manipulate the oven
Right.
is.
That'd be
absolutely
helpful
real.
if you could let us know what incidents you've had.
And we
Mr.
agree,
Welch?
and at the same time, we also would note that it doesn't take, the commission should not be approaching this in terms of, exclusively in terms of looking for harms. Example of
I
harm, as you
understand. I
understand.
just was trying to
Just
figure
to
out
be-
where we are today
Yeah,
along the
sure.
lines of Commissioner Adler's red alert or yellow alert.
I mention it
Okay.
only just specifically because it's not, it's very important for the commission to remain focused on
Potential.
the potential
Right.
defects, unreasonable
Right.
risk, hazard.
Mr. Stanislav, you've talked to us a great deal about vulnerabilities and frightening vulnerabilities. Have you given any thought to how you would recommend turning, for lack of a better way of putting it, those vulnerabilities into a standard? Whether it's performance-based or best practices or whatever.
Yeah, and getting back to my testimony, there are a number of guidelines from security firms. The one I think that was mentioned earlier today from the Online Trust Alliance, I was actually a contributor to their IoT trust framework. That came out, I believe, about 2 years or maybe 3 years ago
Okay.
now. So this is, again, well-trod territory. Like we've put this out there. We have it accessible. The National Association of Realtors, who actually has their own lab for smart homes, because that's clearly a part of the landscape now for them as well, collaborated as well for smart home kind of checklists for consumers to use. So there are these guidelines and standards out there available.
But a checklist for a smart home is very different than a standard for an IoT
Two different
device.
documents, yes. There's a smart home kind of, as a consumer, this is a smart home checklist to know certain things. There's a separate IoT trust framework that I mentioned.
Okay.
That is the security criteria and privacy criteria.
Great, that's very helpful. Dr. Matt Wishon, you mentioned in your presentation that there are a number of ways that CPSC could collaborate with organizations like ISO. Where would you start?
So the two ISO standards that I referenced, that's something that industry can certainly engage with. The idea behind those two standards is that every company should have a way that's obvious for a consumer or a researcher to report a flaw or a malfunction of a code-based product, and that the company should internally have a process for handling those reports and iterating their products to address those flaws. So that's the ISO work that took over 7 years to develop these standards. In addition to that, though I think there is distinct jurisdiction for the Commission and the FTC, working with the FTC, the FDA, and other agencies that are thinking about connected devices, including
Right.
DOT and other agencies. I think bilateral working frameworks to discuss
Okay.
the evolution would be constructive.
Thank you.
The author of the UK report, I'm happy to facilitate
That'd be
connection.
great. You can tell I'm running out of time, and I have one more question for Mr.
Sure.
Wallace. Do you think that there's an argument that could be made for why code developers are parties over whom we have authority? I mean, they're not manufacturers, importers, or retailers.
I think there's an argument. I think
Okay.
that I think that if you
You'll follow up and tell me when that
We'll
is.
follow- well,
after
no,
my
I mean,
time.
we'll
Okay.
follow up.
That'd be great. Okay. Thank you so much.
Commissioner Kay?
Thank you, Madam Chair. Dr. Wishon, just to follow up on your baseline of reasonable security, can you give us a little bit more detail as to what that would look like?
Sure. So it's going to be inherently a moving standard based on what the level of knowledge is in the security community at the time. So today, the vulnerabilities that are, say, 5 years old and patches are well known, and the security community would deem it to be something that should have long ago been patched, that's the kind of situation where there was a failure to maintain the safety of the product. So it is by design a flexible standard to recognize the moving baseline of knowledge in the science of security.
Got it. So then otherwise, other than tort law, perhaps, how is it enforced?
So it would be enforced through a combination of private sector discoveries that X product fails to have this several-year-old vulnerability patched, in which case there would be a disclosure and press and potentially a direct notification of the commission, which is something that would be helpful in terms of facilitating the correction of these flaws. So that would be that baseline, and then with the commission's own labs, additional flaws might be uncovered that would similarly be obviously something that should have been fixed a long time ago. And so then enforcement could happen by the commission demanding a recall from the manufacturer of that product. So it would be a public-private effort facilitated by the commission's imposition of a recognition of a baseline of care, and then additional data being made available to facilitate consumers' purchasing decisions, as well as third-party security researchers and interested other organizations to aggregate that data to be able to identify likely candidates of vulnerable products.
Got it. And so you heard earlier today, were you here earlier, were you here from the morning, you heard that at least two gentlemen did not think it was possible really to have an across-the-board approach as to what is doable because of prior experience in the security world. You're shaking your head.
No,
You don't
I
agree
completely
with that?
disagree. Yeah.
Okay.
So
and based on what?
So, for example, there are certain types of vulnerabilities that have been known for over 5 years. Patches are widely available. It is the expert opinion, and I'll defer to the security researcher at the table, but it is the generally held expert opinion of the security research community that there is no rationale for not patching these particular flaws. They only provide a basis for additional risk, and that this is a situation where there is a process failure inside the company in not patching these risks. Also, it's really a win-win for every corporate entity to fix their security flaws. If you're a public company, when the full extent of your security inadequacy gets known in the papers, your share price takes a nosedive. You potentially face a shareholder suit. And the officers and directors, I mean, I would argue there's a fiduciary duty problem potentially. There is no good argument for weak security on the corporate side. It is a win-win for everyone, for consumers, for companies, and for the marketplace.
Stanislav, do you want to weigh in? Or soon to be doctor?
Yes, hopefully in 5 years. So I agree with Andrea, Dr. Magician. Her points are well taken to the impact that, especially small businesses, I've heard innovation a lot today, and I think everyone in the room would not want to stifle innovation in our country. The challenge there is if working with small vendors, as these two examples of my research came through, had we handled it differently, had we not been researchers, had we been attackers, and I published the entire corpus of all personal details for one of these devices, that company would be out of business. They would not have a chance to innovate in the market. They would not have a chance to sell products to consumers. So there's a hugely valuable road for them if they at least let themselves try to strive in the market. And security flaws at a small business that doesn't have large legal resources, that does not have the capabilities to defend themselves, that won't happen.
And in the roadmap that you laid out for steps the Commission should take, including some of the disclosure that you think is worthwhile, how static will those elements be? Or is it possible in 5 years that they would end up being relatively antiquated and we would want different disclosure?
This is a topic that I've, as a theme today, and agreeing with Dr. Matwishin, I think the approaches many of us are thinking about when we say these kinds of standards are if you ship a device with a password, can the consumer change that password, yes or no? I think most consumers would reasonably think they should be able to change the password. Should the device have a backdoor account that the consumer has no knowledge of? That is a very common thing that gets left in accidentally. That is a very simple thing to find and reconcile. that happens. Consumers would not think that. If I said all your video in this camera was going over the internet, over your home network, unencrypted with no privacy, most consumers would think the opposite. So these are very simple, not robust, new age security standards. This is the basis of information security as we know it, and IoT vendors are not meeting even that litmus test at this point.
Got it. Ms. Kang, do you want to add anything to that?
I would also reiterate that vendors often provide privacy notices that consumers don't read, and they shirk the responsibility of being transparent in the marketplace by hiding behind proprietary claims of trade secrets and IP. But what we would say as a consumer group is that we're not asking them to reveal proprietary information. We're asking them to explain in everyday terms what data they're collecting, where is it going to, and what privacy and security standards are applied to the data. And even beyond that, vendors should take measures in the manufacturing process with oversight from regulatory agencies, because self-regulation has not been proven very effective in IoT vendors to implement security measures from the outset.
Got it. And I guess for all four of you, is certification something that should be on the table? And if so, how? I'll start with you, Ms. Kang.
I think that certification is only effective if it has rigorous enforcement and oversight by a regulatory agency like the CPSC.
I think it's definitely a step in the right direction. Again, there are a very low set of criteria that all vendors should be able to meet to sell an internet-connected device in the market. We've seen with the PCI, the regulating body over credit card data, breaches happen. We know breaches happen. The question is, if PCI did not have the guidance that they already provide and have people do self-assessment questionnaires and outside auditors come in, how many more breaches would we have? And I think right now we have no basis, no standard that actually is being enforced upon everyone. And so while I think there's a lot of future state to think about, I also think that there's a lot that could be solved very quickly. And if we had even that criteria and a basic assessment process, even a self-assessment process, we would be way farther ahead than we are currently.
Who else?
If a standard is sufficiently robust, this is an important tool in the toolbox. Certification, or pushing companies to certify, or verifying that companies certify, is an important tool in the toolbox. We see the CPSC use it, for example, in the hoverboard space with regard to electronics and battery systems. It's going to be an important tool.
Dr. Patricia.
There are several different possible ways to structure a certification requirement, all of which would result in better outcomes in terms of consumer safety. And this kind of certification, however we build it, should serve as just a baseline, but not as a ceiling, and it should not limit the ability of industries to self-regulate and nudge themselves up toward more safe products.
Is there a concern, though, that it would become the ceiling and that they would say there's no point in doing anything else?
So it would depend entirely on how it's crafted from the Commission standpoint. The Commission makes clear that it is not intended as a ceiling, but merely as a floor, and that there will be ongoing monitoring and enforcement, and that the private sector and consumer harm as it is experienced, which is exactly what my understanding of the Commission's work is in other spaces, that will inform future enforcement and future oversight of these product categories.
Great. Thank you very much to everybody. No further questions.
Thank you all very much. Thank you, Dr. Matt Wishon and Mr. Wallace, hopefully Dr. Stanislav and Ms. Kang. Again, our sincere appreciation to all of you and the other two panels as well. I think we all agree, at least from this side of the dais, what a robust and interesting and vital conversation we've had today, and we appreciate your input and your willingness to come here and testify today. So thank you to all of you. I want to clarify one point because it came up this morning when Ms. Prince, the second panel, was here from UL, just about UL, the standard 2744. She confirmed for me that that's an outline of investigation. It's not a standard yet. So that, just for clarity on that issue. As a reminder, the written comment period will be open until June 15th, 2018. So any information that may have been requested today or that you would like to add to your testimony, I hope you will feel free to do that, and that invitation is to all of our panelists today. I want to thank our executive director and her staff. lost his Word document. There's nothing more serious than that. I want to thank our executive director and her staff, as well as the Office of the Secretary, Office of Facilities, Office of General Counsel, John McGugan from Communications, for their efforts to make today's public hearing run very smoothly. I also want to comment, as was mentioned this morning, Rich O'Brien from International has been here. Patty Edwards from our Voluntary Standards Coordinator, has been here through the day. Office of Communication was here for most of the day. And so the important components and many of the issues we've talked about today, the right people were in this room and heard your very important testimony. Lastly, and in particular, I want to thank Adair, who is the Supervisory Program Analyst from our agency. Patty, you may be a familiar face to some, but not to all. But Patty really coordinated and put today's hearing together, and I want to express my appreciation to her. She has taken the lead on IoT in our agency, and just recently was out in San Francisco in April and appeared on a panel with one of the former FTC commissioners about best practices for IoT. So the agency has been really looking at this from very many different aspects, but today's hearing really gave us a sense of maybe where we go from here and where we start in our analysis to determine what our role will be in the Internet of Things. Thank you again to all of our panelists, all three panelists who are here today, for their comments, and to everyone in attendance, both here in this room as well as who may be watching online. And with that, we will conclude this public meeting of the United States Consumer Product Safety Commission.